I think it is a clear sign to everybody that the regulator in Nigeria, that is the NDPC, is a lot more active and serious about ensuring data protection is adhered to in Nigeria. I think it also shows that hitherto, where we were not sure or doubted the ability of the Data Protection Commission to go after companies, which is as a DPCO, which is something we always say. I think it's clear to us that the regulator is going to continually strengthen itself by enforcing regulation, by enforcing proper data protection ethics and principles that are there to by companies, both the large companies and the smaller companies. According to the statement released by the regulator, so we must go with what the regulator has said. It borders on, I think, 3 or 4 different core facts. The first is the ability for user rights, which is pretty much what we call data subject rights. I believe the second has to do with international data transfer principles. So how data is transferred amongst countries or amongst locations. I believe there is data protection as it relates to non-data subjects. So the data subject is you and I, whose personal information everybody has. And if I am your client, I am your data subject, or I am a multi-choice client. But then it extends to data that does not belong to multi-choice clients. And lastly, I believe this will also impact on third-party processing. So people who do work or provide other services on behalf of multi-choice, as well as those who are vendors of multi-choice. So those are the 4 classic categories I see the impact on. We, the data subjects, we whose information multi-choice will ordinarily have, how that data is kept or stored, or where it's kept or stored and transferred within or outside Nigeria. In this case, outside, because it says international data transfer. The data of people that are not customers of multi-choice, and I believe strongly third-party processing, so people who provide services on behalf of multi-choice and vendors of multi-choice. I think this is the response is not just to multi-choice, but any multinational. The law is very clear on how we treat international data transfer. If you need to, first of all, the law says that you are able to transfer data outside of the country, but there are, and this is standard data privacy regulation also. There are 2 ways you can do that. You can apply for some sort of agreement with the regulator. First of all, you must reach out to the regulator and tell the regulator the reason why you want to transfer data out of the country. But you must apply 2 ways. You get a covering, almost like a standard letter that says, this, my business requires me to transfer data all the time. And so please give me a flat approval that every time I take data out of the country, you have given me a blanket approval to do that. The second way is to go, every time I'm going to transfer data out of the country, I will need to come to you for approval. So there's standard agreements they're called that you are able to do, and I don't want to use technical terms at this point, but basically those terms say that you get a flat approval from the regulator that covers you all the time, or for each time you're going to transfer data, you get an approval from the regulator. But having said that, in all of this, The key thing for a multinational or for anybody who wants to transfer data is that you must approach the regulator for approval for data transfer. And this is not just this is just not a, I beg your pardon, a multi-choice challenge. It's a challenge for anybody who's transferring data. The flip side of this is that we would also expect that, like you mentioned, any multinational that is transferring data across Africa would ordinarily be aware of the fact that there are local regulations or national regulations that must be applied to in each part of Africa. So be it here, be it other parts of Africa, you must always go to the national regulator for approval, or even conversation with the national regulator to say, this is my business requires this, and so I would like for you guys to advise on the best way. But like the flat two ways, in general, data privacy principles is that you get a flat covering for all data you're moving, or each time you have to move data, you justify to the regulator why you're moving data. I think for me, it's a very clear sign by the regulator to the effect of we are here to enforce data privacy in Nigeria. I think it's also very important for companies operating in Nigeria to ensure that we don't get to a point where we are being given fines, because the fine sends a signal. It sends a signal, a reputational risk signal. It sends a signal to other regulators. So for me, what signal will it find to me as a data protection fine to me as a multinational signal? Reputational risk, taxation, because then you're doing digital transfer of data. What does the law say to that? There are other regulators or agencies in Nigeria, and I presume across the world also, who are also interested in consumer protection, and you know who they will be. So from a perspective of the fine does not signify just the value, but also the import of data regulation in Nigeria, and also rings the bell out to everybody to say the regulator is able to reach out to different companies and enforce regulation. So the fine amount is quite weighty, but that is also contextual. But the message is that the regulator is going to enforce data protection, as it were, in Nigeria. For multi-choice service providers, I think, you can also argue that because we do not understand, and this is the awareness part of the equation, because a lot of us do not understand our rights as data subjects, and I mentioned data subjects being you and I and people who anybody has our personal information. Personal information is any information you can identify me with. The problem is because we don't understand or we're not aware of our rights, you may argue that the impact might not be heavy, but you can also argue that people start to know more, because anybody who's a user of the pay service will ask questions as to why or what is this thing about. And so it will raise awareness. It will also impact on other service providers, because at this point in time, what you would then say is people to start asking questions as to what data is being kept about me. Have I consented to that data? Have you given a third party my data? Are you using my data for services that I didn't subscribe to, so non-services that I didn't give you my data for. So this will start, I think a bigger question, a bigger import to this is the message of awareness to we, the data subjects, that we have our rights and we should ask questions where we're not exactly satisfied with the sort of services we're getting in terms of the data that companies are keeping about us. The message is clear. In my experience in Nigeria, we continue to drive awareness. We continue to push the message of awareness. We continue to try and educate companies as to the import of data protection and data privacy. We hope that companies stop paying lip service to it. There is also that general tendency for people to not place a lot of emphasis on it because there has been no pushback by the regulator. And so we see that these signs, and there are increasingly more actions by the regulator, should hopefully help businesses to start to see a need for data protection. And these things are very simple. I mean, follow the basic principles of data protection. In this case, ensure, and particularly those companies who trade or have international dealings, not necessarily because you're a multinational, but because you're even dealing with any international company, they will demand data protection policy or what you're doing with data protection. So that's very important. If you're transferring data, make sure you follow the guidelines on data transfer. If you're not audited, make sure you do an audit, make sure you train your staff, increase awareness, ensure you have policies, and ensure that people you're working with, again, third-party companies and third-party providers, as well as your vendors, are also adhere to principles of data protection. Because when the regulator comes, it is you that they will hold liable, not the third party. The third party is responsible to you, and you're responsible on behalf of the third party to the regulator. So these are the things I believe will happen, and or should happen, or businesses in Nigeria should start taking into consideration. No business is too small. As long as you're holding people's data, we would expect that you follow suit and adhere to the principles of data privacy. Not necessarily until when the regulator shines their light on your business, but that you do it as a matter of fact. I'm keeping people's data, and so I should be responsible for their data. Not for my data to be seen on the streets of Lagos, with their carousel. I've seen something like that happen. So I think the key thing is for businesses to wake up and realize that the importance of data privacy and protection in the country. I think across Africa, message is very clear. Nigeria is a forefront runner in the game of data privacy. And in fact, the regulator hosted all the regulators from Africa a month ago or so, I believe. And the message is very clear. What will happen is, I am even aware that in some countries in Africa, they're taking their cue from Nigeria and what we're doing in Nigeria. Barring one country in Africa, I think the rest of Africa is playing catch up to Nigeria, because we have very comprehensive rules in Nigeria. So I'm quite sure that we will see a follow-on effect of this in other parts of Africa, especially countries where multinationals, and perhaps arguably this particular multinational plays, people will shine their lights, because it is an important player in the pay TV business, and any multinational in that matter. So the bigger thing is that we are setting standards for the rest of Africa, and possibly in countries close to us and who are also taking a cue from us. We hopefully see that there's increased awareness. And this awareness story or this awareness message is not a Nigerian message. We operate across Africa, and we have seen the same thing in Botswana, in Zim, in Zambia, in Ghana, across Malawi, and places like that. It's the same message that data protection is very important and should not be taken lightly. I see that businesses will get better with enforcing data protection. I like to mention to just associate data protection with cybersecurity, because you cannot separate the two. And increasingly also with artificial intelligence, because the data that is being fed into these language models and that we are all clamoring for is people's data. So if you merge those three things together, the concept of data protection, cybersecurity, and artificial intelligence, you see there's a huge pot or huge space for action going forward. So I'm actually quite excited about that, and I'm quite confident that we will see regulators in Africa step up to the plate and act as swiftly as other regulators across the globe. I sort of slipped it in the last conversation about the if you like, the triage of data protection, cybersecurity, and artificial intelligence. That we cannot separate those three things. And going forward, I mean, exciting as AI is, the biggest challenge for AI is data and data protection. How do you, or ethics as they call it. So there's the whole gamut of AI governance, but AI governance is all about ethics. What do you do? How do you do? How do you avoid bias? How do you avoid things that will dirty your data? So I think it's very important to stress that going forward, data protection professionals will have to or naturally extend to cybersecurity, because the data is kept in the cloud. But more importantly, that data that is being fed into artificial intelligence is also protected or treated properly.